Joining me in the studio once again from Pace Law Firm, senior litigator Alex Viduras. Thanks. Welcome back to the studio.
Thank you very much.
So, Alex, you do a lot of seminars around Southern Ontario, educating the medical community about the laws that affect the patients in their life. Why the medical community? Why are you educating them?
Well, first of all, I practice in the field of personal injury, and obviously, so we bump up with the medical profession. But really, what I'm trying to convey to many of them is that, in my view, we're in the same business, and the same business being healthcare. The doctors and the paramedics and the nurses and all of these professional medical providers try and improve the life and the health of their patient, and they do it mostly by hands-on, by touching the patient, by delivering primary medical care. The problem is that once they leave a hospital, OHIP fundamentally shuts down, and they're left on their own for funding. For example, if you have someone who's catastrophically impaired and they're immobile and they have a catheter or they have a diaper or they're mentally impaired to the point where they would not know what to do if a fire alarm went off, that costs thousands, if not millions of dollars. And it could be up to 24-hour-a-day attendant care.
Really?
And so, who pays for that? Who pays for that is usually insurance companies.
You figure, I'll just call my guy at the office in the insurance company and say, I had an accident, you got to take care of me.
Yeah, it really doesn't work that way. I mean, on certain levels it does work that way. My bumper's dented, and they'll probably pay for your bumper.
Exactly.
That's not particularly controversial. But the more money you ask from someone, the more resistance you naturally may very well get. And so, if you are significantly injured and you're asking for $100,000, $200,000, $1 million, $10 million, you can meet with a lot of resistance, and they're going to pull out all the stops. They're going to hire fancy defense lawyers, and to do what they can within the law, which is fine. They have their rights as well, but to do what they can within the law to make sure that they pay out as little as possible. And it's my job to get you what you deserve. Frankly, not more and not less, but to get you exactly what you deserve. And if that's $100,000, so be it. If that's $10 million, that's what it is as well. So, but the point I'm trying to make is, I try and tell these medical professionals that we're really in the same business, and it's a different side of the same coin.
Right.
That they put their hands on the patient to fix them, but I get the funding for them to do that once they leave the hospital and once they're on their own back into the community. And I think frankly that's a very reasonable thing to do, and that's my job.
One of those seminars about Ontario legal system, we're talking about the process of getting compensation after an accident. Explain a bit about this process.
Yeah, well, so first of all, even to this date, people throw in the word no-fault benefits, and they think that maybe sometimes you can't even sue in a car accident, and that's not true. So there are two basic things you can do if you're injured in a car accident, and if you're not at fault, so if someone else has caused the accident, you can sue them, you can sue the at-fault person, and really what you're doing to a great extent is suing their insurance company.
Right.
You can sue them for what's called pain and suffering, and you can also sue them for housekeeping expenses that you now require that you can't do on your own. And you can also sue them for your health care, some of the things we've been talking about.
Right.
And you can also sue them for any loss of income or out-of-pocket expenses.
Oh, really? Okay.
Now, the other thing you can do, if you're at fault or not at fault, so this one doesn't depend on fault, is you can claim what are called accident benefits. And you claim those usually against your own insurance company. But if you don't, there's a hierarchy of insurance companies that will have to pay. So there's coverage for everyone, one way or another. And they pay for things like, they also pay for a form of loss of income. It's called income replacement benefits. They pay up to 70% of your gross wage, or up to a maximum of $400 a week. If you've purchased optional benefits, you can get housekeeping benefits paid for, so they'll pay for someone to come and clean your house and take care of your house for a certain period of time. You can also claim what are called attendant care benefits, and I sort of touched on that earlier. There's overlap, but they'll pay for an attendant to come in and care for you. If you're catastrophically injured, for example, that coverage is up to $1 million. And they will pay for your medical and rehabilitation expenses that are not covered by OHIP, which unfortunately many times is almost practically everything.
So this is my own insurance company. Now, will they offer these things to me, or do I have to go dig and say, am I covered for this? Or how do I know if I'm covered?
Well, I think a lot of times they may suggest coverage, but they do it in a very subtle way that is missed by most people. Usually what they do is they simply send out a package that you fill out and apply for what are called accident benefits. But they don't really explain it. They don't sit down with you. And, frankly, I'm not so sure that that is completely their job.
Right.
They're there for their own interest. They do have duties to you, but the duty includes sending out the package, adjusting the package, accepting the package and dealing with it. But the real interest comes where you hire your own lawyer. And that lawyer is there 100% for you. And their only interest is getting you what you deserve.
Right.
And frankly, that's how we get paid.
All right, think about it now. I'm in a car accident. My back bumper got munched in when somebody didn't hit the brake hard enough at a stoplight. Okay, damaged bumper, no cuts or bruises. No, I don't have to go to a hospital. But then, days later, the pain starts kicking in. Is there a time frame? Am I only allowed, say, with 24 hours or within a week to file a claim? How would you approach that?
Well, and that happens a lot. The law says you're supposed to advise your insurance company of the accident if you're going to claim for accident benefits, those accident benefits we talked about, within 7 days of the accident or as soon as thereafter, on a timeline that's practical thereafter. Okay. So, for example, if you're in a coma, and you only get out of the coma after a month, then you advise them a month later, and you'll be fine. The real problem is, you're right. If you're fully awake and fully cognizant, and you advise them on the 10th day or the 20th day, you may run into trouble. But generally, I've found that insurance companies aren't sticklers for that. Especially when you can say, listen, at first I didn't feel a lot bad.
I had a headache, but it went away.
But it went away.
My back, my neck hurts, the aches and pains are coming in.
So I haven't seen insurance companies be sticklers in that regard. Now, the next limitation period is once they send you that package to fill in for accident benefits, you have 30 days to send it back.
Okay.
Now, they do become a bit more difficult about that if you delay. Now, I can't imagine they're going to give you a hard time if you're... I don't recommend this, but if you send it back on the 31st day, you should be okay, but I don't recommend it. These are the timelines. 7 days to notify them, 30 days to fill in the package once you get it and send it back. Other big limitation periods is if there's a denial or a termination of accident benefits, you have 2 years in which to commence mandatory mediation at the Financial Services Commission of Ontario, which is a tribunal that deals with these things. You also have, and it does get complicated, but for the sake of argument and for your listeners, you have 2 years from the date of the accident in which to commence a lawsuit against the at-fault party for your pain and suffering and for those other things I already mentioned. The truth of the matter is, in terms of lawsuits, the government has made it more difficult for people to sue. There's, for pain and suffering that's determined to be worth less than $100,000, there's a $30,000 deductible.
Wow.
So you don't get the first $30,000.
Right.
So if we all agree that your damages, your pain and suffering is worth $100,000, you'd get a check for $100. If we all agree that it's worth $99,999, you'd get a check for $69,999. On top of that, to be able to sue for pain and suffering, you have to meet what's called a threshold. Your injuries have to be a permanent and serious impairment of an important mental, psychological, or physical function.
Wow.
And so the government's making it more difficult all the time for people to sue. And so it's very complicated. And unfortunately, what they're doing is they're keeping lawyers employed because the system requires the intervention and assistance of a lawyer. Healthcare in a lawsuit against an at-fault party also requires you to meet that threshold. But claims for loss of income or housekeeping, you do not have to meet the threshold.
Oh.
So it's
Yeah.
It goes on and on. So actually, one of the reasons why I mentioned this threshold is, although I said you have 2 years from the date of the accident in which to sue, the actual law says that you have 2 years when you knew or ought to have known that that your injuries exceed the threshold, meet or exceed the threshold, or that your injuries would be worth $30,000 or more is when you actually have time to sue. So in other words, that can extend the 2-year limitation period from the date of the accident, but you'd be much safer diarizing that 2 years, calling a lawyer right away.
Sooner the better.
And off you go.
You mentioned lawsuits against at-fault drivers. I know when this came in, it was so confusing. Do I have coverage? What can you recover in a lawsuit against another driver when we're at fault?
Yeah. Well, again, and I've been sort of dealing with that, but if you think about it, if you're at fault,
yeah,
there's no one to sue. You can't sue yourself.
Right.
So unfortunately, if you lose control of a car and end up, skidding into a pole, that's your fault, and you can't sue anyone. But even in that situation, you can claim accident benefits. Now, from the at-fault driver, if someone else is at fault and caused the accident, together with claiming accident benefits from your own insurance company, you can also claim, as I said, you can sue them for your pain and suffering, you can sue them for your loss of income, and you can also sue them for your housekeeping assistance, tenant care assistance, and medical assistance. So those are the things you can sue at-fault drivers for. And there's overlap between the accident benefit world and what you can sue for.
What should someone expect from their lawyer? If I contact you, what are my expectations?
Well, I mean, I think you should expect a lot from your lawyer. You should expect them to be very knowledgeable. You should expect them to have trial experience. You should expect them to be courteous, to be forthcoming, to be honest. You should expect them to maintain contact with you at all times, to maintain their reporting to you, to keep you in the loop as to the status of the case, where we're going next, what the strategy is. You should be in contact with them all the time. They should be available. They should be receptive. And they should move your case forward as though it was their own case.
A lot of questions to think about. If somebody listening right now wanted to ask you questions, how can they get a hold of you?
My direct line is 647-789-1962. We have offices here in Collingwood, in Owen Sound. We have offices in Toronto and Etobicoke and Scarborough and Toronto. And we're always available, and we're also in your community.
Senior litigator from Pace Law Firm. Alex, thanks for coming in.
Thanks a lot.